and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. How are you today?
I'm very well, thank you. The sun is shining, which is a nice relief from grey and rain that we've had recently.
It is. Mm-hmm.
So we're here to talk about a case called MVL Properties Limited and the Leadmill Limited. And it's a case from a very special day, the 19th of Feb, which everybody knows is your birthday.
It is.
And it was a High Court decision relating to the 1954 Landlord and Tenant Act, and in particular, Ground G, which is occupation for your own purposes. So do you want to start with giving us some background facts on this?
Yeah. Well, who would have thought it? The day I turned 39, and this was all going on in High Court. But anyway, it's been causing a bit of a stir in Sheffield by all accounts. It's the Leadmill is a sort of live music venue in Sheffield, which was opened up back in the early 1982, as a sort of community project in a derelict and disused Victorian flour mill in Leadmill Road in Sheffield. And the latest lease of the Leadmill, the lease auditors had done a lot of work and sort of fitting it out and so on. And we're entitled to compensation at the end and take quite a lot of the stuff with them at the end of the lease. But the current lease was from October 2003. It was backdated to March of 2003, but it was a 20-year lease, which was coming to an end. And the landlord, MVL Properties, they served a Section 25 notice and opposed a new lease on Ground G, that they wanted to run their own live music venue from the premises, that's what they're into. Something called the Electric Group, who've already got music premises in Brixham and Newcastle on Tyne and Bristol. I'm assuming you're living in Bristol, that you know it well and go there most nights.
I'm off there tonight, in fact.
Yeah, Nelson Street. That's some of the background. The tenant had basically objected to this on various grounds. The landlord wanted to run a similar sort of live music venue. And the tenant's main arguments were, I didn't think there were a bit of a sort of much chance of success, but A, that you can't occupy for your own purposes, and the purposes being the same as the tenant's purposes. And B, I've never known this one be argued before, but it's worth throwing in, I suppose, it would be a breach of their human rights, and goodwill would be breached. All the goodwill would go to the landlords and their new live music venue. And you'd still turn up and wouldn't even know there was any difference. And that's basically what it was all about. A breach of human rights. Article 1 of the first protocol of the European Convention on Human Rights, and a breach of a right to peaceful enjoyment of your possessions. So that was the background, and that's what the court had to decide upon.
So what did the court decide then?
But it's quite a good sort of summary of the various stages that you have to go through to prove, if you like, Grounds F, which is demolishing and reconstructing, and Ground G as well. I've mentioned this in courses over the years, but the first stage, there's a two-part test really as to whether the landlord can succeed, and it's up to the landlord to prove it. The first, it was a case called Gregson and Cyril Law Carpets back in 1963, which first sort of discussed it. But the first part of the test is subjective. You've got to have a genuine intention to occupy for your own purposes, just like you have to have a genuine intention to demolish and reconstruct, and that's subjective. I remember, as I mentioned in courses, Cunliffe and Goodman from 1950. The Lord Justice Asquith, as they were, basically said it's got to be out of the zone of contemplation and into the valley of decision, which is wonderful words. We should still use that kind of language. So Cunliffe is not actually, everybody quotes it, but it's not actually about the 54 Act. It's about diminishing of the value of the reversion and how to calculate landlords' damages and dilapidations claims. But that's a bit of an aside. And it was held that the subjective test that the landlords had a genuine intention in that they'd agreed undertakings that they would carry out this business and they'd run their music venue. The second part is more objective. You've got a real chance or a real prospect or a reasonable prospect of bringing about your intention. And there was much discussion about the finances and how much it was going to cost and how much it was going to cost to fit out the premises. The landlord estimated £2 million, the tenant £5 million, but the court seemed to side in favour of the landlord's evidence. And they quoted another one I mentioned over the years, Dolgethley. You remember Dolgethley Golf Club?
Mm-hmm. Yeah.
In 1998, that you shouldn't be subjected to a minute examination of the finances and so on. It might be doomed to failure, but you can still have that sort of objective, real chance, real prospect of bringing about the business use that you intend. And they made clear, as again, there's no doubt about it, that intention must be at the time, not when you serve your notice, but at the time of the court hearing, if there is a court hearing. And one of the most famous of all 54 Act cases, Betty's Cafe and Phillips Furnishing Stores in 1959, the House of Lords, as they were, made clear that that's the case. That's got to be a case at the time of any court hearing. There's another case I don't think they mentioned, Spring of Sutton Coldfield and Summerfield, where they said if it's the time of a full court hearing, not just a summary judgment. And so that was sort of satisfied as well. The other thing they discussed is that you have to have the intention to occupy for your own purposes, not immediately on getting possession, but within a reasonable time. And the tenant was arguing because of the fact that the tenant could remove lots of things and the landlord would have to fit out again. This would take 18 months, and that's not a reasonable time. The court accepted the landlord's argument that it's more likely to be something like 6 months, quoted a case called Method Developments and Jones in 1971, which made it clear you got a reasonable time to actually carry out the venture. They also said that the tenant couldn't be benefited by the fact they'd left the property as a shell, as they were entitled to do under the lease. So there'd be a much, much greater fitting out time. 6 months was reasonable. They actually also said that it's not just the fact that you must sort of start running the business, the music venue, but you go into occupation almost immediately to start the fitting out process. So they succeeded on that one as well. And all in all, well, that. There was the sort of the 54 Act as we know it side, but then they dealt with the human rights claim. Shall I tell you all about that?
Yes, please.
Say Article 1 of the first protocol of the European Convention of Human Rights, which is enshrined in the Britain and the Human Rights Act, gives you a peaceful right to peaceful enjoyment of possessions. And the court accepted. There'd been a Dutch case called Van Maal. This is nothing to do with the EU. It's the Convention on Human Rights, but there'd been a Dutch case called Van Maal in the Netherlands, which had said goodwill could constitute possessions, but there was no breach because you're not entitled to an absolute renewal. It's contingent on the landlord opposing, and there's always a defence of it being in the public interest, and the court decided it was in the public interest anyway. So that failed as I thought it might. It's amazing how many human rights claims are being brought in property-related areas nowadays. All in all, the tenant failed, and it was in the Sheffield Press, apparently too early before the judgment, with the possibility of contempt of court. And that's it, Lizzie.
So what is the significance of the judgment then, Richard?
Well, I mean, at worst, and I'm not suggesting here this was a 20-year lease and the like, but at worst, it's Ground G has been known as being a deliberate way of basically getting the tenant to do all the dirty work I mean, the argument that the landlord can't use the same, sort of the premises for exactly the same use as the tenant was never going to succeed. There was a case, a strange case that sort of manifested itself in several different cases called Humber Oil Terminal Trustees and Associated British Ports back in, I think, 2011, which had basically confirmed all that in an appeal case. So that was never going to happen. But at worst, as I say, it's well known that landlords give tenants, they probably think they've got a degree of security. They're in the 54 Act, a shortish lease, and the landlord lets them build up the goodwill, do the dirty work, fit out, and then kick them out. As I say, not here necessarily, not here, but it's been known to happen. Classic of things like restaurants and takeaways and this kind of thing, where you've got big fitting out costs and a lot of goodwill to build up if you're new to the business. And you shouldn't be having short 54-hour protected leases. They should be longer leases with breaks if your business doesn't do well. Or, I think better still, a contractual option. So if the landlord opposes a new lease on ground G, you've still got the contractual option to renew, which you can exercise. Could lead to less stamp duty, land tax, or land transaction tax in Wales liability, because you pay on the basis of the duration of the lease. 10-year lease with an option break after 5 years or whatever is a 10-year lease. 5-year lease with an option is a 5-year lease. So that's the best bet, and practitioners need to think about it.
Thank you very much, Richard.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.